All right, welcome everyone to the Audit radio show. Today's guest is the DUI guy, Larry Foreman. He's an attorney that works on cases particularly involving driving under the influence and those type of charges. You should definitely check out his channel if you want to see some really welcome everyone interesting to the case law radio show and various trial footage. He definitely puts together some really good content. And with that, I'd like to offer you the opportunity, Larry, just to talk about your channel a little bit more and let the viewers know, what they could expect.
Sure thing, John. Thank you for that lovely introduction. For those of you who don't know me, my name's Larry Foreman. I'm an attorney,
really content.
and I practice
with that,
here in
I'd
Louisville,
like to
Kentucky.
offer you the opportunity, Larry, just to talk about
my
your channel a little
firm
bit more.
specializes in DUI cases. There are about 3 lawyers. We have a case manager and a few other staff that assist me in my day-to-day. But I kind of started my channel early on in my career, but it hasn't really gained ground until about almost 2 years ago. And I never anticipated such a reaction, so I kind of ignored the channel for a very long time. And then a couple of years ago, people started noticing. It started popping up. I was getting views, and I didn't know where they were coming from. And so I started adding more videos to the channel, hoping that the viewership would continue, and it did. And so I've been posting ever since. I mostly post hearings that I've done, courtroom hearings. These are all live. These are all real courtroom, real cases, real judges, real prosecutors, real clients. And I've done some trials as well. I've posted some trials on my channel. And I've also done some live events on my channel. I would reserve like a Saturday, and I was doing them weekly for a while. I've stopped doing them at the end of July, just kind of taking a break, kind of figuring things out. Where do I want to go with this? If I'm going to continue doing the lives as I've been doing them before, do I want to morph them into kind of like a civics series where it's going to be more educational and structured? I'm going to be like kind of a mini professor type deal, or do I want to keep going? I haven't really decided yet, but the lives will be coming back. So some of you, I don't know if my viewers are watching this or will be watching this on the rerun, of course, on the channel. The lives will be coming back probably maybe mid-fall, maybe sooner. I haven't, like I said, really decided. But for those of you who are interested in anything law, anything jury related, anything judge, specifically DUIs, this is the bulk of the work that we do. Because of COVID has really kind of pushed us in a slightly different direction. We do a lot of car accidents now as well, just because, people, I always say it's good for society. People are not out drinking and driving. That's excellent, but it's bad for business. And so we kind of had to, like many lawyers, kind of branch out and we do a lot more criminal work, which was already in the works before COVID was even on the map. But we now do a lot of car accidents and other types of criminal law. So definitely you're going to be seeing some of those hearings eventually when the courts reopen.
Yeah, and just to let everyone know, you can find a link to his channel in the description section of this live stream. And, it's interesting you were talking about how you did the live, sessions, so to speak. I noticed that you had one about First Amendment auditors that was from last year, I believe.
Long time ago. Yeah.
Yeah, I watched that one. Had some interesting opinions and insight on that. And, I advise everyone to take a look at that as well. But let's move right along into the questions. I wanted to ask you, there's a wealth of legal possibilities to pursue once you, get past that bar exam. And I was curious about what made you focus on DUI cases.
So when I was in law school, they always told us, and this is absolutely true, you're going to change your mind about what you want to do once you graduate at least a dozen times. And that's not an exaggeration. I mean, I think I can recall, I don't remember what they were, but within the span of a month, I probably changed my mind like 3 times at one time. And the reason for that is because in law school, you're exposed to a lot of different things. You may go to a lecture and hear from somebody who practices in commercial litigation and just instantly, fall in love with it. You may take a course and absolutely realize that you hate criminal law and you never want to touch it, whereas before you thought you're going to be a public defender and open up your own practice. Yeah, so many things are thrown at you, and they're very fast, they're very dense, and the spectrum is very wide. So it's not uncommon. We did have some students who came from specific backgrounds who I know that we had the son of a local judge in my class. In the class before, there was a female who later actually became a judge because she is the daughter of the clerk in Jefferson County. So she had the name, of course, which was recognizable during the election. So a lot of these characters, I shouldn't say a lot, some characters have a path that they kind of go to law school, walking in, they know what they want to do. They may even have a job lined up. Some of our classmates, I recall, even had were sponsored by a law firm. They're very few, but they were there. And they were maybe a paralegal or a runner or what have you. And then the law firm said, look, we'll pay for you to go to law school as soon as you graduate, you come work for us. And that's exactly what they do. So they have a job lined up. Now, I didn't have any of those things. I was a philosophy major in undergrad, and I pretty much had 2 options coming out of law school. Well, 3, unemployment being the third one. With a philosophy degree, there's really not much you can do. But the other 2 options were either teach, which I could see myself doing, but it doesn't really, you don't make a lot of money. I think it's a miserable gig. And the other option was to take the to take the LSAT, the law school admission test, and go to law school. And that's exactly what I did. And so in law school, I was exposed to obviously all the courses. The first year are locked in. You have to take, everybody are literally in this. You learn your classmates very intimately. And you take the same courses day in and day out. You take contracts, property, civil procedure, the basics. And second and third years when you really start exploring. You have your roster and you start looking at what you want to do and what kind of lawyer do you want to be when you get out. So I always drifted towards criminal law because I always found it the most fascinating, but I didn't necessarily know that I was going to be a criminal defense lawyer. Early on, and this was something that actually stuck with me for a while, a very long time, until I actually graduated and realized the prospects for doing it are very, very difficult to really accomplish realistically. And I wasn't being very pragmatic. It was more of a dream, is white collar crime. But white collar crime, because I'm a numbers guy, some of you may have heard the joke that, we don't do math. That's why we went to law school. Most law school people who go to law school, they're very bad with math. I see myself as an exception. I'm a numbers guy. I like numbers. I'm the weird guy who actually enjoys doing his books. And so I always thought that doing some type of maybe SEC litigation, like white collar crime, fraud, tax fraud, multi-million-dollar cases would be really fun, really interesting. Little did I know it's a very difficult niche to get into, especially with no experience, and firms were not hiring at the time. I graduated in a very strange time when in the 90s, law students, law school graduates were very sought after. You were wined and dined, just come work for us. We need bodies. We need to fill in the law offices with bodies just so that we can churn, do more work, and more work. Well, with the advent of Google, Facebook, and so on, the modern client has become a lot more sophisticated. And law firms could no longer afford going to these $300 lunches on the client's dime, because now the client was more educated, was more well-versed, was able to do their own research, and they weren't as married to the law firm as they were before. So as the years passed, the 2000s, I graduated undergrad in 2010. That's when I started law school. I went back to back, high school, college, law school. There were no breaks for me, just the summer each time. So I got done very young. The people that were coming out of these law schools either had they had fewer jobs, much fewer jobs, year in and year out. And interestingly enough, 2010 was kind of a weird year, because that was kind of the last time that there was fierce competition to get into law school. And I had several options. I ended up going to the University of Louisville Brandeis School of Law, and they were only taking 1 out of every 14 people. Competition was fierce. They had like 2,000 some odd applications, and our class was like 145 going in. So it was very, very difficult to get in. And little would I know, in 6 or 7 years, they would barely be able to scrape, 150 applications to fill their seats. Believe it or not, it's gotten that bad. Wow. I don't know what it's been like in the last couple of years, but the last I heard in like 2016, 2017, it was very, very bad. Very bad. People didn't want to go to law school. There were no job prospects out there. I think it's getting a little bit better now. I haven't really kept up with it. And I'm sure COVID may have put a dent in it, or maybe vice versa. I have no idea. Like I said, I haven't kept up with it. But so with me graduating law school, I had to figure out what to do. And I've done some interviews. I've got a couple of job offers, nothing I really was so married to that I wanted to do. So I sat down and I started researching. This is post-law school. In law school, I did study criminal law. I knew that this is what I wanted. I took criminal law courses. And after I graduated, I kind of sat down and I started researching the market. And very quickly, I've learned there's one field that is mysterious. And let me explain what I mean by that. You have in the criminal, if you break down criminal law, what type of evidence do most cases have? You have testimonial evidence, and you have physical evidence, and we can throw in circumstantial. Circumstantial evidence meaning the facts point towards something being a fact, even though you don't have direct evidence to show. So you can infer through deductive reasoning that this is what the evidence is. Mm-hmm. So let's take, I always like to compare, because people think, DUI it's just a simple, you're drinking, you're driving, you're either guilty or you're innocent, right? It's I can see that. And when I was looking at it, that's exactly what it seemed. until you start scratching under the surface. So let's take a murder case. For instance, what does a murder case have? What type of evidence? You have a murder weapon, possibly. I mean, obviously it exists. You may have it, you may not. It would have possibly fingerprints on it. You would have a dead body. If it was a gunshot that perpetrated the fatal blow, then perhaps you would have an exit wound, an entry wound. You would, if you have an exit wound, you would have a forensic evidence of the bullet hole in a wall, let's say, and so on. So what do you really have? You have forensic evidence, you have potentially circumstantial evidence, as we discussed, and you have physical evidence, the murder weapon, the casing, the bullet, maybe, clothing, bloody clothing, and so on and so forth. And then testimony of the detective, testimony of bystanders, witnesses, the suspect, and so on. Confession, perhaps. And that's it. That's the entire case. So perhaps formulating a defense is not the easiest thing in the world, and I'm not saying it is. But as far as evidence goes, that's it. That's the entire case. When it comes to DUI cases, especially if you have a breath test result and, God forbid, a blood test result, you are dealing with so much more multi-layered types of evidence that absolutely do not exist in any case, period. In a breath case, you're dealing with a machine that has that tests the alcohol molecules. You have in a blood case, you have a machine, the gas chromatograph, that tests the blood molecules for alcohol. You are dealing with physiology. You're dealing with in physiology, what I mean by that is the individual's lung capacity. Are they a smoker? Do they have asthma? Did they exhale it once, twice into the machine if it's a breath test? Did they hyperventilate? Did they have a temperature? Were they high on something else that maybe elevated their temperature and changed the course of their breathing to where the number does not correspond accurately to the breath test? And I could go on and on and on. There's just so much in DUI cases that doesn't exist absolutely anywhere else. And I found that DUIs are just, nobody really either takes them seriously in the lawyer field. A lot of lawyers see it as easy money. You just go in and you plead guilty. But there's just so much, if you want to do them right and you want to do them well, there's a whole lot more to the surface. And like I said, you have to look at the records for the machine. You have to look at this one thing that we started doing more and more here in Kentucky is to look at not only the chain of custody, but the actual, what we like to call the blood kit for the blood results in our blood cases. Because in the past, and I'm a victim of the same ordeal. The prosecutor gives you one piece of paper that says your client's alcohol level was such and such nanograms. This is marijuana. It would be, in marijuana cases, it would be nanograms per milliliter, for example, or for alcohol, whatever their number is, 0.137 milligrams per grams per milliliter. Excuse me. And you would look at this piece of paper and that's it. This is the damning evidence. This is the end all and be all, the reason to plea, right? And you can't win. So we started digging deeper. We started getting the lab report, the actual photographs of the kit, the chain of custody. Where was this blood stored? How long was it in point A going to point B? And so on and so forth. And you find, I mean, I cannot tell you, it is a gold mine. It is a gold mine. And a lot of lawyers just, even, I'm freely talking about this because, and I know most lawyers, even when they hear it, they won't do it because it takes a lot of work. It's a lot of effort. A lot of clients can't pay. And the reason they come to us is because we already know how to do all this stuff. We don't have to start from scratch. And so I get a lot of calls. People just say, I don't know how much you are, but I just need to know the price because I already want to hire you. I just need to know how much and if I can afford it, because they've done their research. They've watched my YouTube channel. They understand that we are the go-to. So that's what I did in 2013. I read the book by Lawrence Taylor and Stephen Oberman called DUI Defense. And it's a thick 1,800 page treatise. If any of you can't fall asleep at night, I recommend that book. It'll knock you right out. It's a dense, complicated, just comprehensive treatise on what DUIs are from start to finish. Anything you can think about DUI related, you'll find in that book. And I still use it in my litigation to this day. And I devoured that book, and then I put my skills to the test. I figured, why not? I went on, and I have a link on my website, larryforemanlaw.com, larryforemanlaw.com. On the bottom right somewhere, there's a link to it. It's an AMA, an Ask Me Anything on Reddit. And I've since done another one a couple of years ago just for funsies. But I tested my knowledge. I said, ask me anything. I'm a DUI lawyer, or at least I'm pretending to be because I didn't have any clients at that point. And just ask me anything. And people were impressed. Just the fact that I had the book knowledge, even though I didn't have the practical skills yet. I realized the knowledge was there and the knowledge was sufficient and at least passed the test of the internet, which I think some of you will agree is pretty hefty because the internet is very unforgiving. And yeah. and so I just started advertising. And
so you would say it's a lot of that was the intricacy of a DUI case, and that sort of interested you, and then that sort of leads to being able to successfully defend a case that most lawyers don't even attempt to. I find there's a lot of parallels in that philosophy with First Amendment auditing. Because for auditors, it's extremely difficult, or not just for auditors, but for anyone who has their civil rights violated by police. Finding representation, especially at a reasonable price, can be extremely difficult. And we'll talk about that more later. But
sure.
I wanted to hang on to the DUI subject for a moment and ask you some things like. What should people know about DUI cases that most people don't?
So DUI cases, as I've already alluded to, are very unique. They have a lot of evidence that are sitting below the surface, and unless you know where to look and how to look for it, you're not going to be able to win. I mean, if you just read a citation and that's all you have, and you're just going to try a case with that information and that alone, you're going to lose. And that's the majority of cases, unfortunately, is what happens. But with DUI specialists like myself, we know, and this is a scary statistic. I have a rough estimate that I've gathered over the years. It seems to me that about 1/3, and listen to this number very carefully, about 1 out of 3 clients that I represent are innocent of the crime. 1 out of 3 people that call me have not committed any crime.
So how does that happen?
And well, let me go from the side, and I will explain.
Okay.
Back in the 1940s 40s and 50s, I want to say, the government realized very early on that with the advent of the automobile, that it could be a potential cash crop for the government. And I read this book on speeding tickets very early on in my career. And I learned that it just became a free cash crop for the government and police departments. I know a lot of auditors like to joke. What do they say? Instead of protect and serve, they collect and something. I can't remember. I'm sure you probably know this, John.
Um, I don't. It's not coming to my mind. I know the phrase you're referring to, but I can't remember exactly how it goes. But I
Yeah.
do hear that some. There's versions of it as well. So
Yes. Yes. So you know what I'm referring to. They've become collection agents for their respective governments. And at first, again, like anything else, it was innocent. They had it. It all boils down to having a solid story, a solid. It's almost propaganda-esque as to why we're doing it. Safety. If people are speeding, it's unsafe. People are, dying on the freeways and car crashes and so on. So we're going to implement speed laws. We're going to issue speeding tickets to individuals who are not buckled in and who are speeding and so on and so forth. So it became a cash crop. But what happens with any type of new source of income? At first, it's extra income that the government uses. Eventually, it becomes a staple. And before you know it, it becomes something that they can't do without. And it becomes a necessity for the government, for these police agencies. So, what ended up happening is, there's all these rumors, which some police officers behind closed doors have admitted to, that quotas exist in their police departments. I'm a firm believer that they do have some type of informal, not on paper, word of mouth quotas that they must meet. But obviously, you'll never find it in any written materials. So enter the 1980s, and speeding tickets and speed traps are everywhere. And DUIs are not a new thing. People have been drinking and driving since the inception of alcohol and the automobile. Alcohol obviously has been around for a whole lot longer, but thousands of years. But the automobile being a fairly recent invention, obviously that combination eventually reared its ugly head. And so an organization by the name of MAD, which I'm sure you're all familiar with, Mothers Against Drunk Driving, and I think they now have Dads Against Drunk Driving. They started to, again, under the guise of we're doing this for safety and so on, which is true. Again, I'm not here to advocate that drinking and driving is safe in any way, shape, or form. But it's very dangerous when you have an organization with an agenda, and they will go and achieve their goal at any and all costs possible. And so they started uh, changing the laws. They started advocating for more harsher, stricter laws. I mean, I'm sure you can all remember the comedians and even just older folks who would joke about getting caught drinking and driving. The cop would just give them a ride to their home. Well, those days are gone. Why? Because of the push to criminalize, and not just criminalize, but to profit from these DUIs. So what happens? More and more DUIs are being looked for. There are all these deterrent campaigns that cities begin to attempt to implement, and they realize very quickly that there's really no correlation between trying to deter drunk drivers and a drop in drunk driving behavior. People are going to be people. College kids are going to be college kids. They're going to drink and they're going to drive. It's just part of life. And so police departments, like I said, remember I talked about how initially it becomes kind of a new source of income, and DUIs are much, much, much more beneficial for the government. Each DUI in some states can run several $1,000s in fines and court costs to the government, whereas a speeding ticket, I know in California they're pretty expensive. $300-$400 speeding tickets. In Kentucky, they're a little bit cheaper. They're about 180 with fines and court costs. But a DUI, even in Kentucky, a first offense, in fines and court costs, you end up paying about $776 or $669, depending on the type of case. So, I mean, you can't even compare $180 versus almost 700, right? Or over almost 800 for one case. So a lot of local police departments in outside of the city realize that this is something that they can capitalize on. And here's where it gets hairy, because I still believe that they do have some type of quotas, even for DUI cases in a lot of police departments, if not maybe even all of them. And so when you have that pressure to have an arrest, to find these cases, police officers, and they know this, the majority of people can't afford a lawyer, let alone a good lawyer who knows what they're doing and how to defeat the case. I can't tell you how many calls I've received. Hey, I pled guilty a couple of years ago. Can you look at it? And I just, for curiosity's sake, I look at the case and I realize this is so beatable. This is so ugly. And you just pled guilty. Well, yeah, my lawyer said there's nothing he could do. And maybe that's true. Maybe I'm missing something. I don't know. I wasn't there. But a lot of times I do see a lot of holes that it could at least be exposed and explored, and they never were. And so a lot of these cases that I get, and they're more and more and more common, and this is a staggering percentage of the cases that we represent people on, are people sleeping in their cars, getting intoxicated, getting in the car and trying to sleep it off. And what do they get as a reward for their responsible behavior? Is a DUI arrest and a DUI charge, which is ugly in and of itself. They were doing the right thing. I mean, it could cost them their job. It could cost them so many things. And it's definitely going to cost them a lawyer if they want to at least try and get out of it. And police officers know that the majority of people either can't afford a lawyer, they won't go for a lawyer, they'll just plead to get it over with. And that's why they're making all these false arrests.
Well, just to interject a little bit here, what you're talking about as far as, sleeping in your car, for example, and it costing people so much, a great example of that is what happened to Rayshard Brooks in Atlanta. Where the Wendy's was burned down in protest because of his shooting. When the cops arrived on the scene there, he was asleep in his vehicle and had been drinking. And he ended up, of course, resisting the officers, and, the whole thing played out the way it did. But it all started with someone sleeping in their car and doing something that could be considered relatively responsible.
Exactly. And it's happening more and more, again, because I can't put it more simply than this. You are a bag of money. This is how I like to put it. You are a bag of money to the government. That's all you are. And they're interested in a quick plea of guilt, pay your fines and get out. But the problem is, for the government, that's it. You're in and out. Next. But each and every single one of these nexts is an individual with a home, with a family, possibly children, a job, a career, a home, a car, a loan, a mortgage, possibly student loans. I mean, and they're stuck. They're stuck, and the government is taking advantage of that. Now, again, I'm not saying that's every case. But it's a staggering number, way more than it should be. A lot of the cases I get are a good run of the mill. I was at a bar. I don't think I was drunk, and I got caught speeding or something like that. I get a lot of those cases. I also get a lot of cases where they probably were under the influence. I don't discriminate. I represent everybody, and everybody is entitled to a defense. So, what I think every citizen should know about DUI cases, to go back to your original question, John, is that not every case is born equal. And so when you hear about somebody getting arrested for a DUI, until you hear their story, to try and reserve judgment, because there's a lot of stigma. And I understand it. I understand where it's coming from. I'm not faulting people for it. I'm just trying to make sure that they are educated enough to understand. Unless you hear the story of how it happened, don't be quick to judge, because, and I'm sure you will admit to this as a reporter, a lot of times reporters ignore the facts that hurt the article. They want to portray it in a certain way and paint it in a certain light that benefits the reader and the readership, to get the angle that they want to get on the article rather than get the full facts and the full story.
Oh, absolutely. And, that's even more prevalent in today's time. And that type of practice is a lot of the reason why I stepped away from the field of journalism, because you just have to throw your morals out the window often when you're working for a publication, particularly ones that are, which is most, that are at the whim of their advertisers. And, all they care about is the bottom line, and it's just difficult to exist in that ecosystem of reporting if you care about your ethics,
Sure.
So you covered a lot of stuff about this, and one thing though that I think that we should touch on is how important remaining silent can be during a DUI stop. And obviously, it's something that you should do in almost every police encounter, but I just wanted to get your take on, the importance of that within the context of a DUI stop.
When a police officer is talking to you, you shut the hell up. That's the bottom line. That's literally could be the end of the topic. Now, of course, I'm going to dive in more, but that's the bottom line. Police officers, I've said it before, and I'm going to say it again, they're not your friends. The whole good cop, the bad cop, good cop scenarios that they portray, it's all a game. These are all interrogation tactics. They're psychological tactics to get you to open your mouth and start talking. Once you start talking, it's very difficult to shut your mouth, because you've opened the door. You've popped that cherry, if you will. And especially in DUI contexts, when the individual may be under the influence of something, indeed, whether or not they were driving or were not driving, and with respect to the vehicle they were in, you got a looser tongue. Absolutely, no question about it. Back when I used to drink, you become a lot more uninhibited. You become a lot more relaxed. Alcohol is it is a stimulant, but the after effects are, of course, of a depressant nature. So you do become more loose-tongued, and there is a tendency to want to explain yourself to the officer. Officer, it was just one beer, right? Is the most deadliest question, because up until this point, the officer doesn't even know that you have been drinking. And when you say you've had one beer, what does that tell him? Number one, you'd had more than one beer. Number two, you have been drinking. And that's all he needs to begin his DUI investigation. So they want you to start talking. They want you to admit where you were, what you were doing, and so on. You are under no constitutional obligation to talk to the officer. He cannot, or she cannot, force you to speak to the officer. You can politely refuse. You don't have to be a jerk about it. You don't have to be an asshole about it. You can be very polite. You can simply tell the officer, look, I'm not here to answer your questions. Make a decision. Are you going to take me in, or are you going to let me go? And just put your foot down. You, even if you do get arrested, okay, I cannot promise you'll get out of an arrest, but having been arrested does not mean you're going to be convicted. A lot of people see those as synonyms. Well, if I've been arrested, that's it. But that's not true. They still have to prove their case, quote, beyond a reasonable doubt, end quote, in court. That's the magic language. Now, some states, you can define what it is to a jury. In Kentucky, you cannot. But it doesn't matter what state and jurisdiction you're in. So if you don't give the officer any evidence, you don't talk about what you were doing, where you were, how much you were drinking, where you were drinking, and so on, you're depriving the officer of critical evidence that he or she needs to later convict you in court.
Right. And I think a lot of, you saying that people think that going to jail and being convicted are synonyms is a very, very accurate statement. And I think that's a lot of, throughout the time I've spent watching various police encounters, particularly with average citizens who aren't necessarily aware of their rights or, aren't auditors. They have that big misconception that if they go to jail, that's the end, and that they're going to remain there. And just to explore the other side of the coin, for some people, that can be a little bit true, particularly if you're of a lower socioeconomic status and you can't post bail, and then you just have to wait on your trial, which who knows when it could be, especially nowadays. So I want to reiterate that if you are arrested, and particularly if you do have the means to post bail and get out, that's simply where your case begins. It doesn't end there, and you need to remember that as you're going forward. Another thing I wanted to ask you about the DUI scenario, and I think we'll move on to another topic, is whether or not citizens should submit to breathalyzers and field sobriety tests. And I think, I'm not exactly sure on this, but I'm not sure if it's the same in every state where you have a choice. Do you know?
So I know some. Obviously, I don't have all of the answers in all 50 states. But let me just start by saying, if you're in about 38 to 39 states, and those are the numbers, you should refuse the breathalyzer or a blood test if that's an option. I know some states like Tennessee, they have something they call no refusal weekend, where they actually, literally, I've seen videos and photos of this live, personally from live footage, where they will strap you to a gurney if you refuse, and they'll extract the blood by force with a warrant. Kentucky is not one of those states. Our case law is very, very in favor. We have this case called Commonwealth v. Combs, and it basically says, it mirrors the statute, unless there is a death. This is Kentucky only, mind you. Unless there is a death or serious physical injury. Serious physical injury obviously is a broader definition. Broken bones obviously would classify. If you've been in an accident, of course, these are all accident scenarios. Those are the only circumstances where an officer can even get a warrant to extract blood. And obviously, they can never extract breath. Breath is always voluntary. But with the exception of these 11 jurisdictions, I know Nebraska is definitely one of those 11. Lawyers, I know my good friend Bell Island. If you're watching this, hey Bell. He's a great lawyer in Nebraska, and when he heard my spiel on you should always refuse, he just froze, like, no, 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 don't do this if you're in Nebraska. Nebraska is a little different. In Nebraska, the consequences for refusing, they have a separate statute. You have the DUI statute, which is obviously operating a motor vehicle under the influence, which is a criminal offense. And then they also have a refusal statute, which separately criminalizes refusal of a breath test or a blood test after having been suspected of operating a motor vehicle under the influence. So you can be charged with 2 crimes, and even if you defeat the DUI case, you can still be stuck with the crime of refusing, convicted of that, and sentenced, and so on, which is a whole lot more difficult to deal with. Naturally, as one could imagine, you either refused or you didn't. I've had several refusal hearings in my career, and I've only won one. And that's how difficult they are to win, because it's very difficult to prove to a judge that the individual did not refuse, especially if evidence is to the contrary. So the universal maxim for at least almost 4/5 of the states is to refuse everything, refuse the field sobriety test. So let's talk about those just briefly, because they are simpler. In all 50 states, without question, without exception, refusing the field sobriety tests is a must. You, again, just like we talked about, you giving the officer evidence by telling them where you were, how much you were drinking, and so on and so forth, you're giving the officer. Now, they'll never say that they're voluntary. They won't say, would you mind please stepping out of the car, and would you please perform these tests? Do you consent to them? Yes or no. They'll say, get out, stand right here, and follow my finger. People don't even understand that they have the ability to refuse these tests. And then once the tests are started, you just kind of go along with the game. You're gonna do whatever the officer asked you to do in this game of Simon Says. And the problem with that is, again, you're giving them free evidence that if the tests are not performed correctly, people, I read a lot of comments. People like to say, well, he was obviously drunk. He missed the heel to toe on this 7th step or whatever it is. And this is how officers write citations, and people take it for granted. They say that they missed that step. Obviously, they're drunk. Well, I challenge you, every single one of you who are watching this, try and do these tests. Go on Google, look up the walk and turn and the one leg stand. Don't worry about the HGN, the horizontal gaze nystagmus test. That's a little bit more complex. The simple ones, walk and turn and one leg stand. And do them dead sober, and try and perform them in your own living room. And I guarantee that you are going to exhibit clues without even seeing your test. You're going to exhibit at least, and 2 clues, by the way, 2 clues are a fail on the walk and turn and the one leg stand. So you will see how, and you're doing this in the comfort of your own living room, not under the fear that you could potentially be under arrest in any moment. This is done by individuals on the side of the road where it's dark, cars are zooming by. They may be tired, they may be intoxicated, they may be, there's lights, strobe lights shining in their eyes. There's an officer with a flashlight and he's got a gun on his holster. There may be several other officers around. You're nervous, you're anxious, you're scared. Now compound all of that and try and do field sobriety tests in that scenario. They're designed for failure. They were created by the National Highway Traffic and Safety Administration. And in order to truly assess them accurately and to be able to administer them with the anticipation of the results that you should be getting from these tests is damn near impossible. But day in and day out, people rely, and police officers rely on these tests. And it's up to us, the defense attorneys, to educate not just the public, but our jurors. When I'm in a jury trial, I'm also dealing with 6 men and women who think that these tests are infallible, that these tests are perfect, and it's my job to show that they're not, that they are. And you can pass them with flying colors, despite the officer may have noted certain certain clues that the individual has exhibited. And again, you have to remember the circumstances of the individual on the scene. So refusing field sobriety tests, absolutely. Just politely refuse, say, I'm not doing them.
I think a big part of why a lot of people tend to consent to them is because they think it's either do this test or go to jail. And I think one thing that you should definitely consider is that there's a good chance that if you've gotten to the point of an officer wanting you to do a field sobriety test or take a breathalyzer, there's a good chance you're going to jail anyway.
Absolutely.
And so it's kind of, you don't want to give evidence unnecessarily, and it's very difficult for a field sobriety test to prove your innocence either way. So it's kind of it's just like you said, you should just refuse them, in my opinion.
And don't forget that the officer already has in their mind, they already know that you made the admission. Let's say you said you had one drink, one beer. They already know that they're taking you in. They're just trying to pile on as much as they can on their stack to make their case stronger. So if you made the dumb decision of admitting to the officer that you've had a drink, at least make the smart decision of not giving them any more and refusing the field sobriety test. Now, let me jump real quick. I still haven't answered the breathalyzer and the blood test results. So I want to circle back to that just real quick. So in the majority of jurisdictions, as I've said, refusal does have consequences. In all 50 states, there's the implied consent law in every single state. So you will lose your license once you refuse the breath or the blood, 100%. Now, in the majority of jurisdictions, including Kentucky, you can get something called an ignition interlock device that gets attached to your starter. You blow into it. So long as you blow, I think it's below 0.02, you will be able to start the vehicle. Now, things obviously to watch out for are Monster energy drinks. Some of those will trigger those devices. During the wintertime, if you spray a de-icer in your car, that can trigger it. Listerine and anything that has, gum that has any type of alcohol in it will trigger them. But that allows you to drive while you are quote unquote suspended. And usually you can petition for that at the very outset of the case because you've been deprived of your license because of your violation of the implied consent law. Now, in those minority jurisdictions, the 11 that I mentioned, I think it's 11, that if you refuse in those jurisdictions, you will be charged with an additional crime. So in those jurisdictions, you should not refuse. Like I said, Nebraska is one of them. Also, you should never refuse if you are a CDL, a commercial driver's license driver, or if you are a pilot. The FAA and the FMCSA, that's the Federal Aviation Administration and the Federal Motor Carrier and Safety Administration, they carry severe penalties for truck drivers and pilots who are held to a much higher standard than the average driver for refusing. So those are the exceptions. So the 11 states, and if you're a CDL or pilot, you should not refuse. Now, there are some exceptions to the exceptions, I'm sure you all know, in law. But for the most part, this is the universal. And if you refuse, you got to remember, there are 3 types of evidence that an officer can get from you. Possibly even, I would say 4 if you've been driving. Your driving behavior, were you weaving? Were you all over the road? Were you keeping a straight line and so on? Did he pull you over for a busted taillight and then smelled alcohol, Your field sobriety tests, your behavior, I'm going to lump it all together. How you behave, how you smell, how you look. Do you have bloodshot eyes? Are you going to perform his tests? All types of physical evidence that he will see, and you may or may not perform. A breath or a blood test. And what was the other one? I just had it. But essentially, those are the types of evidence that he's looking for. And statements, admissions, statements that you either make or fail to make to the officer. Those are pretty much the 4 types of evidence that he can gather, or she. And the more you provide, the stronger you make their case against you. And if you notice, pretty much all 4 of them are completely within your control. Maybe with the exception of the driving. Those, you may be distracted, you may be on your phone, you may be changing a station on your radio. But for the most part, you see what I'm saying? They're completely within your discretion whether or not to give that evidence. And the majority of people don't even know that they can say no. So refuse, at least in Kentucky, refuse everything. Sacrifice your license if you can. We'll get you back on the road. It just makes your case all that much stronger.
Yeah, I think a big element of what you're saying is to do your due diligence and make sure that you know the laws regarding DUIs in your particular state. And beyond that, you know, it doesn't you don't necessarily have to have a full understanding of all the case law and precedents that surround DUI driving and whatnot in the country as a whole or in your state in particular, but you should at least take some time to, you know, at least glance at the statutes and make sure that your state isn't one of those 11 states that does have a refusal statute and whatnot. I want to shift gears here and move a little bit away from your expertise, so to speak, but still you're an attorney, and I think that, you know, you have valuable opinions considering that you spend time within the justice system and you know how it works more intimately than most people. And so with that, I wanted to ask you what your opinion of the justice system as a whole is. And with that, does the current system still represent what it was designed to be?
The short answer, no. I think it's unfair. It has gone so far away from keeping the peace and keeping the interests of justice to making money. It's become purely a for-profit organization that cares less and less about its citizens and cares more and more about the bottom line. And we've seen that, and I think you already alluded to this a little bit, John, in the bond system. There have been horror stories of individuals who may have committed a small traffic infraction, pled guilty, and owe a fine. They missed their court date because they can't pay the fine, so they're afraid to show up because they don't want to get locked up. Now there's a bench warrant, a warrant that has come from the bench, from the judge, for their failure to come to court. And they can't hire a lawyer to set aside the bench warrant because obviously they didn't have the money to pay the ticket in the first place. And so they're on the run, figuratively, of course. And one day they may be driving around, they get stopped, and they get arrested. Now they have new charges for whatever they got stopped for. And they're also sitting in jail on a $250 bond for the bench warrant that they failed to address previously. But they can't pay the $250, and they're sitting in jail, and they're racking up more fines and more. And now you have jail fees in Kentucky. I think it's somewhere between $25 and $35 per day to be in jail, especially if you've been sentenced. Now, if you're awaiting pretrial, it's a little different, but still, you can't get out because you can't pay that darn $250, and people have spent months, years, even. I'm sure there's well, I know there's like a 60-minute or something on that of these people who have spent months and years in jail on speeding tickets because of the bond system. Now, a lot of it in recent times, over the last literally, I would say about a year and a half, 2 years, has started to kind of change. There's been a huge, huge, huge shift, and we've seen it here when individuals fail to come to court. There are two things that a judge can issue. One is a bench warrant or a BW. And then the second thing they can issue is an FTA, or a failure to appear. So all they do is they don't issue bench warrants on these small traffic infractions anymore. This is pre-COVID, by the way. And they just issue FTAs, which does suspend your license because you haven't come to court, but at least you don't have a bench warrant looming over you. And this is this push to modify the whole bond system in the United States, and Jefferson County in Kentucky is no different, in the sense that we're going away from that for simple, quote unquote, I like to refer to them as simple traffic infractions, speeding tickets, registration, tags, insurance, things like that. Anything that is not a misdemeanor or a felony. So, and you got to remember, let's look at the other side of things. We looked at the judges and the system in that sense. Now let's look at the other side. Let's look at the prosecutors. Prosecutors are human beings. Prosecutors are lawyers with a law degree. They have an ego. Lawyers, I myself am guilty of it. We're all aware of our egos and how big they are, and how we protect our egos, and how sometimes we're willing to go above and beyond. And I've seen it. I'm not one of those people, but I've seen prosecutors argue endlessly and emptily on a losing argument, in behind closed doors, not in courtrooms as well, which is much less frequent, just to prove their point, to protect their ego, because we presented the law to them and say, look, you can't do this. The law is clear. Here's the case. No, that's not possible. I don't care. I'm not doing that anyway. But the law here, I just explained to you what the law, they're so bruised, they're so fragile, some of them, that they can't even accept the fact that they lost the case fair and square. And it's really depressing, and it's really sad. Now, usually it's newer prosecutors. We don't really have that from veterans. They kind of know it's just the nature of the beast. It's just business, Some of you are movie aficionados may know where that quote is from. It's just good business. And that's a problem, because if you have a zealous prosecutor who is out to get you just in the name of protecting their ego, where's the justice? And if, leave it to the public defenders to argue the whole justice theme. And I think we've fallen away from that. It's become a money churning scheme. It's an ego riddled place, and it's just the nature of the game,
right?
And I don't think it's fair. I don't think that it's designed, whatever it was designed for, is to enforce the law and protect the people. I mean, it still does that to an extent, but those high-end felony cases, which I typically don't touch, the burglaries, the robberies, the murders, those, of course, are a whole different beast. But they're a fraction of a fraction of a fraction of the court cases that go through. And the majority of them are all in district court. The traffic tickets, the assault and batteries, the thefts, the petty thefts, the DUIs, all those cases are the ones that are really the majority of what goes through the court system. And that's where this chaos ensues.
Yeah, and I think, speaking on prosecutors, they have incentives to put people in jail, whether that be establishing a reputation so that they can pursue some sort of legal or political position in the future, move up to a district attorney or a judge at some point. They'll have a track record to back up, hey, look at all these convictions. I made this a safer place. And it seems as though that's a very common theme, particularly in more rural areas where you don't have a whole lot of crime. And any time that they can say that a prosecutor can say that I've put this many people in jail who are doing crimes, that they tend to weigh that as like something that's favorable for them. But, I always tell people, err on the side of caution when you hear a prosecutor say that, because it's not something to brag about. It's not something to bolster and say, look how many people whose lives I've ruined, and some of them may be justified. It doesn't, having a large track record for prosecuting people is not very appealing to the average person when you look at the intimate details of what went into creating that number. And a lot of that comes from the chaos, as you said, the chaos of the legal system and the big egos that fill the courtroom.
And I must say, not all of them are like that. Actually, the majority, thank goodness, are not. But it's the bad apples that kind of ruin it for everybody else. And we've all heard about this is typically in higher end cases, like I said, in circuit court, felony cases, where prosecutors even withhold and hide evidence. We don't usually see that in misdemeanor court. I mean, the cases are just so petty, and they're usually more obvious than not in circuit court cases. But it's those bad apples who do and have this type of attitude and behavior that ruin it for everybody else.
Right. And how do you think the justice system could be fixed at that level? Obviously it does work.
$1 million question.
Yeah, right. I'm not so much looking for these grand philosophical and paradigm shifts that we could make as a society, but more so what, are there practical solutions for the average person and their, journey through the courtroom once they get a speeding ticket or DUI, for example?
Well, obviously, hire a good lawyer is the number one thing. Now, I know a lot of people would want to represent themselves. I think it's always a bad idea. We've all heard the old joke. But the key is you're dealing with a judge. If you go in there by yourself, you're dealing with a judge, a prosecutor. Who else is in the courtroom? You have the pews, the people sitting in the pews in the gallery. You have a bailiff, maybe a couple of bailiffs, a few clerks, and some other prosecutors walking about. There is not a single person, not one, except you, in that courtroom who cares about your case as much as you do, and who cares about justice, or at least quote unquote justice, being served. So if you go in there by yourself without knowing what you're doing, we have a tendency to trust people. In essence, this is how society functions, because if we couldn't trust one another, what if that person just pulls out a knife and stabs me? It wouldn't work for a very good society. So we're intrinsically already trained and psychologically geared towards trusting others. And when you have a judge and a prosecutor who present an offer to you and say, look, if you plead guilty right now, we'll give you $100 fine, court costs, blah, 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 and you get to walk away today. And the person thinks, wow, that's a pretty good deal. Sure, yeah, I'll take it. And they don't think twice about it. All the prosecutor wants is for you to sign on the dotted line and walk away. They'll give you the bare minimum just to get you out of that courtroom so they can lighten up their docket. So the one thing that's become very obvious is how to make it better. We need more courtrooms, which good luck getting that, but we need more judges, more courtrooms, more prosecutors to lighten the load so it doesn't become a churn and burn game, next, 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 as quickly as we can, because we have a huge docket to get through. Now, there is another line to that, and I think it's actually the complete opposite, and that is to have more lawyers set cases for trials and clog up the system ever more. That's the completely opposite solution, because if judges are going to have to start scheduling it, and COVID is already pointing in a direction that we're going to see something like that very, very, very soon once the courts reopen, because people continue to commit violations, commit crimes, commit felonies, and the system is getting more and more and more clogged up with all these cases, and there's no outlet for these cases to be resolved.
And COVID,
So,
just to add to that, COVID has increased the rate of a lot of crimes, particularly domestic abuse,
yes.
drugs. A lot of things have been sort of rejuvenated, if you will, by COVID, and the way it has forced us to stay inside and around a certain group of people.
Yeah, exactly. So now you have this influx with no outlet to get these cases resolved. So we have seen some positive results in our cases already, with prosecutors simply trying to get their cases off their dockets. And I think, and this is the one thing that attorneys really have trouble with. Again, it's that whole part of that whole ego defense that I've already alluded to. We are not very good at banding together, a lot of us, and we see ourselves as lone wolves and trying to accomplish our own goals. So when somebody says, like myself, set more cases for trial, challenge prosecutors, challenge the other, that a lot of it gets brushed off like, look, you do you, I'm going to do me. And I understand that. It's part of human nature. But if we could somehow, even without banding together individually, simply start setting cases for trial. And the problem is, again, a lot of lawyers just don't know how to try cases, or they're afraid that they're going to lose, or they don't know how to even go into it. Lawyers used to, you couldn't even call yourself a lawyer unless you knew how to try a case. Now, I think, 99 out of 100 lawyers have never tried a case in their life. Everything gets settled out of court for various reasons. Again, I'm not here to play the blame game. A lot of cases really do just get settled out of court, and for various reasons. But a lot of lawyers have practiced for decades and have never seen what a jury looks like. And it's growing. The numbers are growing by the day, again, for various reasons. So to call yourself a trial lawyer really is kind of it's a proud thing if a lawyer can actually say, yes, I try cases and I'm able to try cases. So I think if we clog the system up with more and more and more trials, we're going to be able to get better results all around, because trials, like I said, and don't just set everything for trials. Set the cases you really think you can try and win. Okay, I'm not saying just to set cases, just to set them. That's ridiculous. But the ones that you think are beatable and can be beat, they should be set for trial. And again, that's the flip side to fixing the system, because and this is true. Like I said, sometimes lawyers will walk in, negotiate with a prosecutor, try and squeeze them for a deal on a very, very good case, and the prosecutor just won't budge. Why? Because the prosecutor knows this lawyer will never, even if they set it for trial, they'll never try the case because they don't know how. They've never tried a case. They have a reputation for it. And if a lawyer who has tried cases sets a case for trial, well, the prosecutor knows, maybe I should think twice about it. Maybe I'm not going to win this as quickly and as easily as I thought. I'm up against a pretty serious adversary. So reputation, of course, is also there. But um,
Well, that goes all the way back to the whole ego thing that you were talking about, and sometimes a lack of an ego, as far as your confidence in yourself to win a case, can contribute to you not wanting to try a case. Like you were saying, it's disturbing to me to think that there are so many attorneys out there who have never tried a case, and it makes me think back when I graduated from journalism school. I graduated with many people who had never written an article. And it seems like, that's kind of a common theme in a lot of industries where you're they're getting away with the absolute bare minimum, and it's not just lawyers, journalists, it's also police officers, it's also the McDonald's workers. It seems like there's sort of maybe a psychological element to that. And it's just a part of the human condition to want to get as much for as little as possible.
without getting too philosophical, it all boils down to the concept and principle of entropy, the
Yeah.
degradation of the gradual degradation and slow degradation of society. So I agree. And it's no field is safe from entropy.
Right. And I actually explored that topic of entropy in an upcoming episode, talking about the chain of communication between, someone calling 911 and that information actually getting to the police officer, and how that information degrades as it passes through each messenger. And there are a lot of implications involved in that. And entropy is such a universal idea. It applies to so many different things in relative terms. And I think, if you don't have some awareness of that theory of entropy, it's difficult to see how things get to where they are. And then when you take a step back and you apply the idea of entropy to any situation, it tends to make more sense, when you add that additional chaos, so to speak. There's one more question I'm going to ask you, and then we'll take a few questions from the chat and maybe a call or two. So, as an attorney, what advice would you give to someone who is doing auditing, or who's thinking about doing auditing?
So from what I've seen in the auditing community, um, it's a very unique situation because let me explain from an attorney's perspective. What are attorneys used to? You were in the process of doing something you weren't supposed to do, maybe even happened, quote unquote, by accident, let's call it. When it comes to speeding, you didn't notice your speed or whatnot, and you got caught. Oh crap, now I got to deal with this prick who's coming at me with, okay, yeah, I'm sorry, officer, blah blah blah. All right, now I got to get a lawyer. Shoot, he got me for speeding 26 over. I don't want to lose my license. I'm in a pickle. They call me and they say, look, Larry, can you help me out? I got caught speeding. I don't want to lose my license. And sure, yeah, absolutely. I look up their case. I understand what it's about. I've dealt with it before, so there's this familiarity and a cookie cutter situation. In the auditing community, it's a little bit different because you are almost putting yourself, I don't want to call it in harm's way, but you're putting yourself on the front lines. You are actively taking a video camera and going to the lion's den, if you will. You're going to the police department. You either go inside or you videotape the outside. And lo and behold, sooner or later, 1 or 2 or 3 or 10 lions are coming at you. Hey, what are you doing here? You're not supposed to be here. Well, where is that written? And then you begin your interaction. And of course, more often than not, I see these interactions resolved very innocently. Eventually some type of sergeant, lieutenant, captain, whoever comes out and says, this is not their first rodeo, or they may be familiar with the auditing community and so on. And they'll tell their subordinates to leave you alone. Yeah, they can be here. There's nothing you can do about it. This is fine. So when a lawyer receives a phone call from someone who hasn't been charged, is actively going into harm's way, trying to put themselves literally on the line of fire, it's foreign territory for a lawyer, because it doesn't comport to any cookie cutter scenarios that we're familiar with. And for a lawyer, that's a scary place to be, because again, we talked about the egos. We like to be comfortable. We like to be in a place where we're aware of what's happening. This is a situation I've dealt with before. I know how to deal with this. Let's go. And all of a sudden, you're stumped. You're kind of in a place where you don't know what to do, and your instinct is to brush that off. This is not what I do. This is not for me. I don't want to deal with this. This is a new area of law potentially I have to study. This is First Amendment. I haven't had that since law school. I'm not interested. So there's all these excuses that a lawyer could begin to potentially thinking about, just to get this potential. Not again, do you even call it a potential client? They may not have been charged with anything. Again, this is even more far removed from the cookie cutter scenario. You're not even charged with a crime. I'm going to be retained to do what now? I'm going to be retained to potentially protect you in case you get arrested after you go and with a camera into the lion's den. And I'm going to do what? If you get arrested, then I get, there's all these unfamiliarities and questions that that arise in the lawyer's mind. So I think a couple of things I will say to the auditing community. First off, you guys are doing a great job. I think I'm a firm supporter. I would not do it myself, again, for various reasons. Partly, of course, because of my position, and number two, I don't have the time. But you are showing to people with, we've talked about egos. Police officers have far bigger egos than attorneys ever will. Ever. Because they have a gun, they have a badge, they have arrest powers, they have a set of handcuffs, they have a radio where they can call for an army to come back them up. I mean, think about it. Think about the level of power that just one police officer has when they're out on patrol. It is insane. It is immense. And what you're doing is you're chipping away at that ego to show, look, you're not impenetrable. You're not impervious to I don't even have a gun. I just have a video camera and my voice. And that's it. That's all I'm walking in with. And you 7, 8, 9 police officers with your guns and batons and handcuffs can't do anything about it, because I'm lawfully on public property, and I'm recording what I'm allowed to be recording. So, excuse me, it's powerful. But of course, it doesn't come without dangers. You could be arrested, you could be charged, you could be, God forbid, it could escalate. I don't think I've seen any auditing situations where it truly has gone haywire, because for the most part, again, it's peaceful, and the auditors are unarmed. I have seen Second Amendment auditors. That's a whole different topic. Those are much more dangerous and more risky, and some people are doing it for various reasons. patriotic and whatnot and so on. But I would suggest talking to lawyers who are familiar. Don't just go calling around for a lawyer, because they're gonna be scared. They're gonna run away. They're not gonna want to touch it. They're not gonna want to deal with you. They're not gonna want to deal with your case, with your situation, because it's foreign territory. It's territory that they've never crossed into. You're not, again, you're not even a potential client in their book, because some of them may happily take your money, but they'll be scared to even do that. So what I suggest is find lawyers who are constitutional lawyers, First Amendment lawyers. And again, I'm not one of them. I do DUI work, criminal defense, car accidents. I'm a bad example of somebody that you might want to hire. Now, because of my familiarity, I might go for it. And I actually had a couple of phone calls of auditors in Western Kentucky with a 270 number who have called me in the past, but nothing ever came of that. I said I would be more than happy to assist. So I'm a unique example. But again, you got to have a goal in mind. You got to remember that the lawyer wants, because we don't want any part of it. We don't want to be actively involved in the situation, because we don't know what you are. A third party. We don't know who you are, where you come from, how crazy you are, what your intentions are, what your goals are. So again, it's also that fear of losing control, of not having control of the situation, of not being fully immersed, and then potentially having responsibility for something that someone else did. But of course, if you go and audit and you do get arrested and you do get charged with loitering or trespassing or what have you, I mean, those are all, or falsely arrested. Those are all scenarios where you should pick up your phone and call an attorney.
Yeah, and I think another apprehension that your average attorney may have approaching an auditing case is that not all auditors audit in the same way, and not all of them have the same degree of legal knowledge, and there are many misconceptions that float around in the auditing community about the law. And, that was sort of the whole premise of this channel, was to sort of dispel a lot of that and give some sort of a foundation for people to build upon when it comes to what is legal and what isn't in the context of a First Amendment audit. And when an attorney has to, approach a case that involves a First Amendment auditor, they don't know whether or not what they were doing was legal, because not all of the circumstances surrounding First Amendment audits are legal, and a lot of them exist in a gray area of legality. So it's difficult to go into a scenario like that with the same degree of confidence that you would have in your average, petty criminal case, or even a more serious case, because exactly, like you said, exactly what you have to do in those circumstances. But with auditing, it's not only is it a new idea, but it has no formulation, and there's no algorithm to conducting a case involving audits.
Exactly.
So, I think that definitely sheds light on why auditors have trouble finding representation. And another element of that is the stigma attached to auditors and who they are and what they do. It tends to be conflated with conspiracy theories and fringe ideologies, and even anti-government and malicious sentiments. And, that would discourage anyone who practices law for a living from getting involved in that for the sake of their reputation, the health of their career, and whether or not there's any real gain to be had in a case like that, whether that be setting a new precedent or financially it being worth your time. So, there's just so many elements to that I think people who are thinking about auditing need to consider that the audit is only where it begins, and oftentimes, what comes after that is more important than what actually happened during the audit. And if you can't find a way to prove what you were doing was accurate in court, then it's going to be a waste of your time, really, to go out and audit. And like you said, there are inherent dangers that you should be aware of. Well, I guess we can take a few questions from the chat. If there's anyone, I see one from Patrick Price that says, if I refuse the DUI walking test because I'm handicapped, do I still have to take a blood test at the hospital? And if so, will they impound my vehicle anyway? And, bear in mind that this is all very state specific, I'm sure. He says he lives in Indiana, and I know you don't practice in Indiana, but if you could walk through, like, for example, what would happen in Kentucky in
Sure.
a case like that.
Sure. And that actually brings up another point, and I didn't talk about, because it's not prevalent in Kentucky. I remember it was a really big deal in New Mexico not that long ago. I think they've changed the law since then, but I'm not 100%. So in some states, if you're convicted even of a first offense, now remember I said convicted, not charged. If you're convicted of a DUI, even a first offense, they can impound your vehicle. So other than losing your license, you just lost your car. And it may be, it may be your dream car. Maybe it's the only car you could afford, and now you cannot afford another one. So now you just lost not only your ability to transport yourself from one place to another legally, you now lost any possibility of transporting yourself because you no longer have a viable means. You're missing the critical element, a car. So Kentucky, we don't really impound vehicles. I don't think I've ever actually seen a case where we impound license plates. If you get convicted of a second, third, or subsequent offense, they can impound your license plate, but not the vehicle itself, thank goodness. But in some states, it's not the same. Now, Indiana may be one of them. I'm not 100%. I'm not as familiar. I'm getting more and more familiar with DUI law in Indiana, but I'm not sure specifically on this. But it brings up another great point when it comes to the performance of field sobriety tests. So in the instruction manual, police officers are trained that prior to administering field sobriety tests, they must ask if the individual has any injuries or anything that would hinder them from performing a roadside field sobriety tests. Well, here's the problem. Again, remember I told you about the whole ego of the officer. He wants you to perform these tests, and by God, you're going to be performing his tests, whether you like it or not. And they kind of skip that question. Now, it raises a whole slew of issues because sometimes individuals will volunteer. Well, look, I have a bad knee. I can't. Well, just do them anyway. Do them to the best of your ability. I mean, and that, again, opens a whole can of worms of legal issues when it comes to litigating the case in court. But what if you, again, can't afford a lawyer? You're just have given them free evidence on a bad knee, and so on and so forth. So Patrick Price, to answer your question, if you refuse the test because you explain to the officer, look, there's no way I can perform these. I'm handicapped. I'm not physically able to perform them in any way, shape, or form to where you're going to be able to accurately determine them. Because you got to remember, the National Highway Traffic and Safety Administration, when they tested these tests as to their viability of showing whether or not an individual is under the influence, they had 100% healthy and young men and women, in their 20s, in the California, in San Diego in the 87, I think is when it was done. The people were very, very young, and you cannot simply administer these tests to somebody who's not physically, almost basically 100%. So refusing these tests, it kind of goes without saying. But then you're probably going to get arrested anyway. Maybe the officer smelled alcohol. Maybe he saw bloodshot eyes, even though it's 2 o'clock in the morning and you haven't slept since 8 a.m. All these things compound your issue. So you're going to get arrested. You're going to go to the hospital. He's going to ask for a blood draw. And in Indiana, as far as I know, there is the implied consent, but it's not criminalized, much like in Kentucky. So refusal will subject you to the license suspension, and they do have ignition interlock, as far as I know. So you can petition for an ignition interlock device. Like I said, if you're not a CDL or a pilot, I would strongly encourage you to refuse both, especially if this is in Kentucky, goes without saying. But I even think in Indiana, I can't give you legal advice because I don't have a license there, but I believe that's the law.
Yeah, that's interesting. How long in a normal case, when would you be able to petition for an interlock device, and how long would you have to be without your vehicle before, you would actually get the device and get your vehicle back?
In Kentucky, almost instantly. So once you are arrested, you're going to be put into the queue for arraignment. Some counties do arraignment the next day, like Jefferson County, especially if you get arrested over the weekend. Again, this is mostly what I'm talking about is mostly pre-COVID. COVID has really screwed things up. So I won't really touch on that. So let's talk. Imagine a scenario where COVID doesn't exist. No,
Sounds
first of all,
good.
that would be nice, wouldn't it?
Yeah.
But pre-COVID, you would get arrested on a Saturday. Let's say you would have to spend the weekend in jail, unfortunately, unless a judge releases you on your own recognizance or allows you to post a bond. So you'll be released on Sunday. But your arraignment, regardless whether you're released or not, would probably be set on that Monday or Thursday at the latest. And at arraignment is when you lose your license. Now, sometimes if you refuse, officers, depending on how experienced they are, corrections officers, they may or may not take your license right at the jail. Sometimes I have seen that, especially when you refuse. Sometimes they erroneously take it, even though you submitted, but that's even rarer. But your license will be suspended if you refuse at the first court appearance. And at the first court appearance is when the lawyer makes the petition to the court. You get the paperwork signed for the ignition interlock device. And then it's up to 2 people to get the ignition interlock device actually installed. Now, I won't go through the steps. I think it's unnecessary, and this is not the right platform for it. But essentially, the clerk has to mail it to Frankfurt, and then you have to go and take your own steps to get the device installed. Sometimes there's a delay on the clerk's side, and essentially it's up to you. It's up to you to get the device installed. And if everything goes right, you can be back on the road within a couple of days. Of course, sometimes it takes longer.
I just want to take a moment here and shout out Dan Lowe and HBO Matt for contributing in the chat. And also say, HBO Matt, I covered one of his interactions in the past where he was recording an officer from approximately 200 feet away, and he ended up getting detained. And at the time of making that video, the settlement amount had not been released, but apparently he says in the chat that he got $75,000 from that settlement. I guess congratulations, you were appropriately compensated. Yeah.
Indeed. Good job, HBO Matt.
Let's see here if we got any more questions from the chat. What can happen when someone refuses to make any written or verbal contracts and vocally claims not to recognize them as authority? That comes from Carolina G. And, you're alluding to some sovereign citizen lingo there. And I think that it's important to understand that case law is not necessarily permanent, and that if you look at certain antiquated case law, it likely has been struck down by higher courts as you progress into the modern era. When you look at a case law, you need to look beyond its face value and consider the context and the history and then the modernization of that case law as well. And a good example of that, which I will be talking about in an upcoming episode, is the Bad Elk case, which essentially concluded that it is legal to resist an unlawful arrest, but that is no longer valid case law, and it has been struck down by courts multiple times, both higher and lower courts. And there was a meme that was circulated, and I believe I talked about this in the top 5 rights you should know or misconceptions about law enforcement, that don't believe everything you read about the law on the internet. And this is coming from someone whose entire channel focuses on that, principle of getting legal information from the internet. But, I'll just say, for example, I can be wrong sometimes. I don't think I have been in the past, but I wouldn't be opposed to being proven wrong in the future or at any point. And I just want to emphasize the idea that sometimes the stuff you read on the internet is not right. And a majority of the sovereign citizen ideology is based on misconceptions and antiquated case law that is no longer valid within the current legal system. Now,
or oftentimes it's even very grotesquely misapplied also.
Yeah, very true. Very true. And the Plummer case is another example of that, which I believe I also talked about. But I wanted to add to that doesn't, when I talk about these laws and how they're no longer valid and how this is how the modern system works, that is not me endorsing this system. And this is not me saying that I agree with this necessarily. My personal opinions cannot be reflected in the way the system currently operates. And I'm just trying to give everyone who watches this channel a better understanding of the current system and how to navigate that effectively. So just bear in mind that just because there's a law that I talk about that an auditor violated or that a police officer did things lawfully, that doesn't mean that they're ethically right or that I personally agree with that. So I just wanted to put that out there. Sorry for taking up the time to say that, but I thought it was important. Okay, so I'm going to try to open up this phone line. Bear with me. This is the first time that I've done this live. I've tested it. I've tested it a few times, and it seems to work well. So here's what we're gonna do. All right. I don't know if any of you have ever used Zoom before, but here is the phone numbers that you can call right now and get into this lobby. What you need to do is dial these phone numbers based on your location. You put in this meeting ID and the passcode, and it will put you into a room with us, and I will allow you to come in one at a time. We'll take maybe 1 or 2 calls, and then we'll wrap it up here. But while we're waiting on that call, we'll get to Never Again's question. Thank you for the $5 donation. Can cops force you to show your dash cam footage? And should you even tell a police officer that you have a dash cam, or just wait and deal with that in court? That's an interesting question.
It definitely is, and it all boils down to what the officer's mindset is, because a lot of them will confiscate, delete, destroy evidence, and then of course never admit to it, never write about it in a police report because they don't have their own camera footage. In a lot of small counties, and it's scary, but it's I have cases exactly mirroring the question you just asked, Never Again, where my client has a dash camera or a cell phone that's actively recording, and unfortunately it's not being stored on a cloud, it's being stored locally. And then that device is either missing, disappears, when the vehicle is towed, it's not nowhere to be found. It's always better to do it in secret. Now, if the officer has their own body camera, of course, anything that they do, at least on the scene, with respect to taking things away from you, is all going to be recorded. And it all depends on where you are in the country, too. I mean, the more liberal states, I think in Florida and California, Georgia, where police officers have far greater training and experience, they won't cross those lines. Some officers in Alabama, I'm sure John would attest to it, in Kentucky, maybe in Tennessee and Mississippi, they're not as kind. West Virginia, they may cross over those boundaries and try and confiscate footage that you're trying to record them on at the scene. Now, of course, it's all unconstitutional. It's all illegal. They cannot do that. But it's going to be your word against theirs. And unless you get to a trial, no one is going to hear it other than the judge and the prosecutor, and of course the officer who committed the atrocity. So should you tell them if they can't obviously see it? I mean, usually dash cams are pretty bulky, they're very visible, but I'm sure an officer would notice it. But I've heard of a case, this is not my case, I'll give you a classic example of how this played out in the client's favor. It was a DUI stop, a DUI investigation. 3 police officers and the client, the individual who got stopped, had a cell phone, and they hit record on their cell phone and kind of tucked it away so it was not visible, and the police officers couldn't see that they're being recorded. So they're being recorded in secret. There was no body camera footage from the officers. There was no dash camera footage from the officers. So the only recording live of that scenario was the client's cell phone. The officers conducted field sobriety tests. They generated a report, and everything, of course, was recorded on audio only. There was no video. And the case gets to court. The lawyer filed a motion to suppress evidence, and I believe the motion to suppress the field sobriety tests. And so the officers testified, and of course, they didn't know about the existence of this recording. After they were done testifying, the lawyer asked the court to play this recording for the judge. And the recording contradicted almost everything important, at least, that was critical to the police officers' case and their testimony. More specifically, basically the 3 officers all perjured themselves in court, and it was uncovered solely with this hidden secret recording by the client. So that's how important and crucial it can be. I mean, the judge was irate when I think, he couldn't dismiss that case fast enough. And the thing is, I'm sure the police officers were reprimanded if at all. If they were, then very little. And they were back on the job the next day. And I'm sure they're still out there without even checking. It's just the way it is, unfortunately. But the recording is important if you can, and if you can do it in secret, that's even better, because especially if they don't have their own equipment. I have never, and I have looked at thousands upon thousands of citations at this point in my career. I have never read a citation that mirrors exactly what happened at the scene of the stop. It's right. Always exaggerated. There are oftentimes false facts injected, butchering of the facts, mischaracterization of the facts. I could go on and on.
Yeah, well, there have been studies about the language that officers use in writing their reports, and it shows that they tend to use adjectives that don't necessarily describe a particular thing, that are so open-ended that you could interpret them like for example, the subject came at me aggressively, and that word aggressively can be interpreted so many ways, and
Very subjective.
yes, it is. And they it seems as though there's such a pattern in that they have been trained to do something like that, and maybe, I can't attest to whether or not that's accurate, but that, the pattern definitely suggests that. And another thing I'd like to add is that you have a First Amendment right to record police interactions, period. And you should exercise that right as often as you possibly can, particularly if you are the one involved in that encounter. And that's my opinion. So of course, take that with a grain of salt. But I definitely think that there's nothing to lose by recording police encounters.
Absolutely. I completely agree.
And with that said, I guess we'll take this first call and see how this goes. Hey, you're on the ATA radio show. What's up?
Yeah, I'm listening to your program, and I just have a quick question.
Sure.
Let me take you off speaker so I can hear you better. Okay. So I just put my notes there. Okay. So I have a question for you, and I don't know how, I've never done this before, so.
It's okay. Take your time.
Okay. Let's see here. Oops. So I had a traffic stop one time. It's 1 in a million, and I just wanted to ask the attorney whether or not it would be legitimate to go ahead and ask this question, because I feel that I told the truth. I took 4 shots of whiskey and a Valium. I passed out at a stoplight, and I was sitting there for I don't know how long. And the cop came up to me, knocked on the window, and I told him the truth right off the bat. He says, "All right, if you can call somebody right now to pick you up, I'll park your car across the street at the restaurant." And they let me go. So I told the truth. Is that a good thing to do if it's undisputable that you're guilty?
Good question.
That is an excellent question. Let me say, what a nice cop.
Yeah.
You got so lucky that the cop was either having a good day or he's just one of those. That you're right. It is extremely rare, especially nowadays, as I've said, with MAD and all those other organizations who advocate for, arrest, prosecution, and conviction of every single one who are even suspected or even borderline, let alone flat out go and admit to a police officer the full unadulterated truth. So I will say that you got lucky. That's definitely not the common trend. That's definitely not how it normally plays out. But would I suggest, you doing that in the future? Absolutely not. As I said, the cop is never your friend. You just got lucky.
Is there anything you wanted to add to that, caller? How are you? He's watching the stream. Yeah.
But would I suggest, you doing that in the future?
Okay, we'll leave it at that for that for that call, and we'll move on to the next one. I hope that answered your question, and I think you're very right about that, Larry. There's, he essentially hit the lottery when it comes to police officers and encounters. Literally. And I've never heard of that happening to anyone that I know. And of course, that's anecdotal, but I'm sure that does happen occasionally. But you probably have a better chance of getting struck by lightning than something like that happening. So we'll move on. And this is the picturesque. Let's see if we can get him in here.
just so we're clear, I'm not an advocate for drinking and driving. Don't drink and drive. But if you do get caught, call me.
Right. Hey, the Picturesque, you're on the ATA radio show. What's up?
Hey guys, thanks for taking my call. Can you hear me all right?
Yeah, you sound good.
Excellent. So my question is, would you give the same advice for refusing breathalyzer and blood tests in states where you do run the penalty of having a license revoked, even if you've not had anything to drink or you've not, done anything that would influence your driving capability? Is that still the advice that you would give in those circumstances?
That's such a common question, and it is a loaded question, the Picturesque, because, well, here's the short answer. If you truly have not been drinking anything at all, and anything that could compromise your position, you wouldn't end up in front of that machine in the first place. Typically, they'll do like a roadside breath test on you. They'll see you blow zeros, and then they'll either suspect drugs and ask for a blood test. And in which case, you got to be careful. If you smoked marijuana a couple of weeks ago, that could show up in a blood test, and you'll be prosecuted for a marijuana DUI, even though you didn't have any marijuana anywhere near you in 14 days. So a blood test is a lot more invasive and a lot more revealing than and maybe you take medication, some amphetamines such as Ritalin or Adderall legally, and they can prosecute you for that, and that's a whole headache in and of itself. I'm not saying those are winnable by the prosecution, but they can be difficult if you don't know what you're doing as the attorney. But if you truly haven't had anything to drink, if you truly are, squeaky clean, innocent, I guess it would behoove you to blow. But again, you don't know who blew into that machine before. I've had cases where the machine is located in basically a broom closet. And, actual drunks would go in and out of that room. People who've been arrested for a DUI and had to submit to a breath test. The whole room, I remember my client describing, the room smelled, it reeked of alcohol. Because, a person who's intoxicated is sitting in that little broom closet and exhaling alcohol molecules with every breath. And then with the next test, is the result inflated? Maybe. And if you weren't drinking at all and you blow into a machine like that, it picks up alcohol on a microscopic level. Okay. These machines are not accurate. And the newer ones are even less accurate than their predecessors, as odd as it may seem. The machines we use in Kentucky were made in the late 80s. We like to joke in the lawyer DUI community that the chip inside these Intoxilyzer 5000 ENs is the same chip that was used for that Pong game. Do you remember the Pong game in the 80s? That's the same chip in that machine, and that's frightening. That's the thing that is processing the information that it's receiving from your exhaled breath. So they're very inaccurate, and they, again, like I said, they pick up alcohol molecules on a microscopic level. And if there's any type of ambient alcohol in the room when you're blowing into that machine, and if you have not had anything to drink whatsoever, you could have what's called a false positive. So of course there's those things to watch out for. Those machines can be tinkered with. Officers will never admit to them, but they can be. So again, should you refuse at that point, it becomes a very loaded question, because if you blow and you blow a false positive, you just screwed yourself ever so much more, knowing in your heart and mind that you are completely innocent of this crime, and now they're building a case against you based on false evidence. So like I said, it's a very loaded question, but for the most part, even if you blow and you blow zeros, they'll ask for blood. And if you refuse, you're subject to the same consequences as if you refused the breath test in the first place.
One thing I'd like to ask about that is when an officer has someone blow into the machine, does the machine record that number, or does the officer actually record that number separately, say, on a report? In other words, what would stop an officer from falsifying that information, if he had the opportunity?
Well, the machine spits out a little receipt-like piece of paper that the officer either feeds in each individual time on like the 5,000 EN. The 8,000 has its own roll on the inside, so you don't have to refeed it each time. You just have to replace the roll, kind of like a cash register, if you will. But the office, once the individual blows, the machine will record the results and spit out what the result was. So the officer can't tinker with the actual printing of the results, but everything that leads up to the subject blowing, again, we don't know the full intricacies of how deep the officer has control over that machine and what they can do, what type of button or lever to press to maybe generate a result that they desire.
Right.
I don't think we have ever. There's always the suspicion that they can do something they're not supposed to be able to do.
All right. Well, Picture S, do you have anything else you wanted to ask?
Well, I guess I just would add to that I think, I share the skepticism that, especially with perverse incentives like we talked about earlier with potential quotas and other inherent things to the human psyche that will potentially lead a citizen to be put in that position, that they may be asked to provide what is, I think what we talked about, somewhat compulsory because of other criminal statutes and the loss of licensing. But it cuts against our general desire to go home, right, in that moment, right, where I know that I haven't done anything wrong. If I can provide that physical evidence, then perhaps I can go home right now. And so I know that that's something that, is the feeling that's going on there that kind of cuts against those two different things. I guess I do have a related question on the way that we're talking about right now. Is there any requirement for testing these devices on a regular basis that would prove the efficacy of the results that they're providing?
Sure, their own internal techs who go machine to machine, month to month, and examine them. And I'll leave you to decide how trustworthy those indeed are.
Right. It seems as though if your devices are producing more DUI convictions, then that provides incentive for a department to purchase more, or the next generation, if you're producing the result that they want, which is, of course, evidence. So
what they do a lot of times, I forgot to mention with these machines, is when one machine stops working properly, let's call it that, gives error messages, insufficient something, or RFA interference, which is radio frequency RFI, radio frequency interference. What they do, and I've seen this, and sometimes you can follow the trail because each intoxilizer has a serial number. What they do is they shuffle these machines around from county to county, and they'll because the machine will work on some occasions but not on other occasions. So they'll take the machine out of county A, ship it to county B, take the machines from county B, take them to county C, and take the machines from county C and bring them to county A, and then repeat cycle with different counties in Kentucky. It is sickening. And they're only doing it because they don't have any money. They don't want to invest into getting better equipment. Repairing these machines is a nightmare. They're old. Getting parts for them is impossible. You take parts from other machines to to replace the ones that are broken or damaged in the broken machine, and upgrading to the 8,000. Forget about it. That's a whole insane increase in costs all around. Now, some counties in 2019, I want to say, is when I first saw it roll. Maybe it was 18. I can't remember. That I first saw these 8,000s roll around. So we do have counties with the 8,000. But again, as I've said before, if you do your research, I don't even need to discuss this on here. If you can do your own research and see, and there are countless of articles discussing how the 8,000 is even less reliable than the 5,000.
All right.
Thank you.
Well, thank you for calling in, Picturesque. I appreciate your questions. They were very good and insightful.
Definitely.
Feel free to call in again. All righty. I think we can wrap it up here. This was a really good conversation. And once again,
I enjoyed it.
Yeah, the DUI guy's channel is in the description. Be sure to go and check out his channel. He has if you liked anything we discussed here today, it's definitely worth taking a look at. And if you'll just stay on the Zoom call for just a moment, and I'll end the stream here. I appreciate you guys. I want to give a shout out to Corey, first of all, before we go. Thank you for your $10 donation. He says that AtA, your channel opened my eyes and enlightened me to views of law enforcement. I used to be of the opinion that cops were never wrong. Such a fool I was. And he's going to keep your number handy, DUI guy.
Well, thanks, Corey Eagle. I really appreciate it, brother. I hope that you guys have learned something, and that's exactly why we do this, is to educate the public, as I'm sure John will agree. We're here to inform you guys of what the truth is, because we're in the trenches. So
very much so. And
thanks for joining us.
Yeah, thank you for joining us. And there's a new episode of AtA coming out tomorrow. And be sure to come back here next Sunday, same time, same place, for the next episode of the radio show. All right.
Thanks for having me, John.